In this training module, I'm going to review the patent application process with you. This includes discussing the various steps in a typical application process and the different steps for provisional and non-provisional utility applications. By the end of this training module, you should be able to understand the steps ahead of you to get your provisional application filed and later, if you choose, pursue a non-provisional patent application. Let's get started. What I want to show you first comes from the U.S. Patent and Trademark Office website. It's actually an older version of the website, and I wasn't able to find this same flowchart when I looked for it recently. But I like the flowchart because it was just kind of an overview flowchart of how the Patent Office views the patent process. I've broken this flowchart from the Patent Office into different steps. I think they've taken it off the website now because it doesn't necessarily work quite as smoothly as the Patent Office makes it look with the flowchart. However, I think it still does give a pretty good overview as to what the process is, kind of from start to finish. And we'll go through this. And then after we look at this flowchart, I'm going to show you a very simplified flowchart that I've created that I think outlines the 5 major steps of a patent. So this flowchart is broken into 3 pages, just for ease of viewing here. I didn't have it in the browser anymore because they don't have it online. I had to pull this off an archived version of the USPTO website. What you see here are the different steps you go through in obtaining a utility patent. Now you should note that this flowchart is really for a utility non-provisional patent application, not necessarily for a provisional patent application, which simply goes through the preparation and filing steps, not the examination and issuance steps. But we'll look at this overall just briefly to give you an idea as to what to expect in the process. So the Patent Office shows that the first step in the process would be for someone to explore whether or not their invention has already been patented. We already looked at this step when we did our patentability search before, but it's probably one of the beginning steps that you should take, as we've done in the prior module. After figuring out whether or not your invention has been patented before, if you've determined that it hasn't been patented, then you go on to determine what type of patent filing you're going to make. And they're really distinguishing here between design, plant, and utility patent applications. This flowchart really is only for utility, so you'll see that the design and the plant patent applications don't go on in this flowchart. And we're not going to review those processes here either, although they're very similar to the steps that happen in a utility patent application in a lot of ways. So once you decide you want to file a utility patent application, the Patent Office suggests that you determine your filing strategy. What they really mean by that is, are you going to file just in the US? Or are you going to file globally? Where exactly do you want to get protection for your invention? Now, this isn't something we've gone over before in our modules, but we're going to go through a little bit of detail on this in Module 4, just to give you a heads up when you get started looking at your non-provisional patent application process. So once you determine that you are going to file globally, then there's a whole other process that you can follow. We're not going to go through that in detail here. We'll talk about a little bit in Module 4 to give you a heads up as to what to expect. In the flowchart at Step 4, the Patent Office suggests that you look at what type of utility patent application you're going to file, whether it's a provisional or non-provisional. In our case, we're of course working on a provisional patent application, so that step's easy. If you're going to file a non-provisional patent application at some point, they also suggest that you consider whether or not you want to do any expedited examination. Of course, a provisional patent application is not examined ever. It just is pending for 12 months and then expires. So the accelerated or expedited examination step isn't applicable to a provisional patent application. In a utility patent application, though, there are some options to make the examination go faster. And we'll talk about a few of those later on so you have a little bit of context when that time comes for your invention. The next step in the flowchart looks at who would be an inventor or who would be filing. So in the United States, as we've talked a little bit before, you've got inventors and you've got applicants. And again, we're going to go more in detail on this when we talk about inventorship prior to actually filing your provisional patent application. But for now, it's really just looking at, are you going to do this yourself or are you going to use a registered patent attorney? And the USPTO has a list of registered patent attorneys if you do decide that you want to hire somebody, either for your provisional patent application or for a non-provisional patent application. You can go there, you can find by state or city or different ways you can look for a registered patent attorney or even a patent agent. And just a brief aside, the difference between a patent agent and a patent attorney is simply that a patent attorney is also a lawyer, whereas a patent agent is not a lawyer. So a patent attorney would be able to help you in a lot of other legal areas besides simply preparing and filing and examining a patent application. Some of those areas would include things like licensing or assigning your rights to somebody at some point in time. So a patent agent wouldn't be able to help you with that because they're not a registered attorney, they're simply a registered patent agent. Of course, this flowchart skips all the steps of actually how to prepare your own patent application, which is why we're doing this workshop. But once you've got it prepared, then you can also prepare for electronic filing in step 7 of the flowchart. This is really where you determine how much the fees are going to be. You would apply for a customer number if you are going to do that. We're going to skip that step here because I don't think it's that important for you. But if you do decide to file multiple patent applications at some point, you might consider getting a customer number so you can have access to that like a patent attorney would have to their portfolio of applications. Once you've got all of your paperwork together, both the patent application and the filing documents, you would then take those and you would go and use the electronic filing system and file your patent application with the patent office. I'm going to go through that in Module 5, exactly what steps you need to take, what paperwork to fill out, how I would do it, and some of the considerations. And then we'll walk through how to actually file your provisional patent application so you get patent pending by the end of this workshop. And that's where the process for a provisional patent application would end, with step 8. You file it, you get a date, you now are patent pending. But as I've mentioned before, there's no examination of your application. There's no formality check other than to make sure that you fill out the documentation that you needed to fill out. But they don't look at what the content is of your application. They don't necessarily look for whether or not you need to have drawings in there. They certainly don't look to see whether or not you have claims in there. And they just let it sit there. However, for a non-provisional patent application, the process continues further because that's where examination would start. It wouldn't start immediately because it probably takes 12 to 18 to maybe 24 months before your non-provisional patent application would be picked up and examined for rejections by a patent examiner. This step 9 is also deceivingly simple because the process of examination is in and of itself its own art, its own complexity. And it takes sometimes many back and forth communications, rejections, objections, many difficulties with the patent examiner, sometimes interviews, sometimes in-person interviews, sometimes even appeals. In fact, you can even appeal outside of the patent office through the courts to get your patent application allowed. The process can be very complex. That's not something that we're going to teach here because in a provisional application, you don't need to go through the examination process, but it's also something I wouldn't suggest that you do on your own or even with an inexperienced patent attorney. I would always use an experienced patent attorney to do that because they've seen how to be efficient in the process and will help you get through most efficiently if possible. Once you've gone through the examination process, there are really two outcomes. Is it allowed or is it not allowed? If it's not allowed, ultimately, that's where you can appeal, you can file some things to try to continue in the process, and you might be successful in those reattempts with your patent application. However, oftentimes it's not, and you'll want to get some guidance as to whether or not you should continue down that path of continuing to pay money and reapplying over and over with the same claims or with the same patent application. Once it is allowed, which hopefully is the case for everyone who's applying, once your patent application is allowed, then you simply pay the issue fee and you get your patent granted. And now remember, you've been patent pending ever since you made your initial filing with the patent office. At this point, though, the big difference is you now are a patent owner instead of just a patent applicant. And if you wanted to, you could go out and you could enforce your issued patent against other people who are infringing your claims in your issued patent. We'll talk about that in a little bit more later. The only thing left to do with that in the United States, after you've got your issued patent and made your decisions about whether or not you want to enforce it, is to maintain your patent. And the Patent Office gives you a couple opportunities to pay additional fees to keep your patent in force for the full 20-year term from the time that you filed it until the time that it expires. If you continue to pay the fees, then your patent will stay in force. If you don't pay the fees, then your patent will expire early for non-payment of the maintenance fees. And those fees are due at 3.5, 7.5, and 11.5 years, and they just incrementally go up. The first fee is relatively small. It's in the hundreds of dollars. The last fee is relatively large in the $8,000 to $10,000 range, or even more, depending on what type of entity you are that's filing. So that's a pretty good overview, I think, of the overall process that you'll go through with the patent applications that you're filing. And remember, the provisional patent application will not go through the examination or issuance steps in this flowchart. It will stop at the application filing stage where you get your receipt and your date of filing and you become patent pending. So here's my simplified process flowchart of provisional and non-provisional patent applications. You'll really go through these 5 steps: preparation and filing of your patent application. And that's applicable to both provisional and non-provisional patent applications, although the preparation steps for a non-provisional are more significant and substantial and time-consuming than a provisional application. But you'll go through both the preparation and filing stages, and the provisional application, that will be your final stage. With the non-provisional, you'll then go through examination. And then if you're fortunate enough to get your patent issued, you'll go through the issuance stage where you pay the issue fee and you are granted your patent. And then you get to decide whether or not you want to enforce that patent against potential infringers. I also wanted to include just a little bit of information in here about accelerated examination. As I mentioned before, there are several options that allow you to accelerate how fast your patent application goes through the examination process after you file. And so this shows just a list of different types of acceleration points and acceleration methods that you could use. None of them really apply to the provisional patent application that you're filing. They're all directed to non-provisional patent applications, either getting something into the patent office sooner or getting it through some of the formalities or the substantive review of your patent application. So this shows that once you've filed your patent application, and again, this really applies to non-provisional patent applications, but once you've filed your patent application, you can take a couple steps. Some of these steps are required to be done at the time that you file your non-provisional patent application. So if you miss doing it at the time of filing, then you won't be able to take advantage of these opportunities. Others are opportunities that come along after you've filed at some time during the examination or formality processes of the overall patent application process. There are different opportunities. Some of them are based on how much you pay the patent office to get put ahead of other people in line. Some of them are based on your age or other special circumstances, perhaps. Some of them are even based on the type of invention that you've created. I've had several clients in the past who were very successful at moving their patent applications quickly through the patent office because their inventions were considered green technologies or clean technologies or medical technologies that fulfilled the requirements of certain programs that the patent office initiated at different times. Once you get to that stage, look at what your options are for going faster if you want to do that and if you qualify. But for now, I want you to just be aware that these are available as potential options in the future. In fact, if you get to the point where you want to sue somebody because they're infringing your patent application claims before your patent application is examined all the way, you can actually speed up the examination to help you get through the examination process faster. And if you're successful, then you can move on to enforcing your patent against those potential infringers. So that's it. You should now have a clear understanding of the typical steps in the patent application process.